If you've been arrested for a domestic violence crime, your pretrial release will be supervised by a family relations counselor. You will meet with this individual on the first court date following your arrest. You will be interviewed about your background, your relationship with the victim, and the incident that led to the arrest. The family relations counselor will also separately interview the victim or victims. The family relations counselor will then submit a written report to the judge with recommendations about the following. Number one, the level of criminal protective order and restrictions that may be placed against you. Number two, the need for a more detailed individual assessment of your situation. And number three, the release conditions, including appropriate counseling and other appropriate programs that you might require. After the arraignment, you will again report to the family relations counselor, who will administratively monitor your progress and compliance with the protective order and all the different conditions of release. Many times you will have been referred to the AIC, or the Alternative to Incarceration Program, that services the courthouse for groups with anger management courses, individualized therapy, group therapy, that type of thing. The Court Support Services Division contracts with private service providers who offer both inpatient and outpatient programs that address domestic violence, mental illness, substance abuse, anger management, or domestic relations. As part of the court-ordered release conditions, the judge will make you participate in one or more of these programs. You will not have a choice in this, but a lawyer can fight this and prevent some of these if you act quickly. It may be possible to substitute privately chosen therapy for a court program if your lawyer coordinates it. If this is more appealing, our office may be in a position to get that set up. The family relations counselor will monitor participation and require that you sign a release of information to obtain any records that they need. Now, the judge can order you to participate in group or individual classes. You can be required to report into a counselor on a daily, weekly, or monthly basis. You may have to submit to urine tests for the use of narcotics, alcohol, or prescription medications. The judge has a wide latitude to set release conditions in the case. Whatever conditions are set, you will need to obey them. This is one good reason why to enlist a lawyer early on in this process, as soon as you can. Once that person is placed under the supervision of a family relations counselor, you must always attend any of their required meetings and fully cooperate with the counselor's recommendations. You must participate in any of the court-ordered programs and comply with any of the court-ordered testings. You can't simply say, I don't want to take your test. You got to do it. You must, of course, obey the protective order and any other court orders that are put into it. And you must live a nonviolent life without any new arrests. New arrests can really hurt your case. On each one of your upcoming court dates, the Family Relations Counsel will prepare a written report to the judge. If you're not in compliance with the release conditions, the judge could raise your bond and put you in jail. So, if you know someone who needs this information, please share it with them. If you have more questions, please contact us. We are here to help.